we come to a very fundamental issue in international arbitration. There is ad hoc arbitrations or institutional arbitrations. Now, both have their set of advantages and disadvantages. Now, let us discuss what are the advantages and disadvantages of ad hoc versus institutional arbitrations. So, what we'll do is let us start off with ad hoc arbitrations. I'm assuming that everybody knows what ad hoc arbitration is. In the event, however, I'll still give a brief background of what an ad hoc arbitration is. An ad hoc arbitration is basically an international commercial arbitration where both the parties decide that they will appoint the arbitrator, they will decide the timelines and the technicalities behind the process of governing the arbitration, and they will henceforth go forward with the arbitration and not submit it to an institution where in an institutional arbitration, an institution administers how an arbitration is normally governed. Now, the thing is, now let's get down to the advantages of an ad hoc arbitration system. Now, an ad hoc arbitration system can be tailor-made for different kinds of disputes. A specific disputes, let's say dealing with oil and mine, can be tailor-made according to the party's wishes, okay, and the rules can be formulated in such a way that impartial proceedings can be gone forward with. Again, there's something called control of process. Control of process is another advantage in the ad hoc system. Control of process is something where essentially both the parties have control over the proceedings, over its mechanisms, over its working, and every timeline that is decided. So that gives the parties a certain amount of flexibility and independence, and also adds to the quotient of confidentiality in arbitrations, so to say. Then we have something that is very important in determining how an arbitration should be governed. An ad hoc arbitration is normally essentially very cost effective. It completely eradicates the cost that is to be paid to an institution for the management of an arbitration. So in situations like this, which is a very extensive cost, is absolutely cut off from the cost budget bracket. The tribunal remuneration is also, unlike institutional arbitrations where tribunal remunerations are fixed and it depends on the quantum of dispute and things like that. The tribunal remuneration can be decided between the parties as per their likings and their capacities to pay the tribunal. Moving on, now we will discuss a few disadvantages that might be there while choosing an ad hoc method of arbitration. There might be adequate disagreement between parties, because when you give that much independence to the parties to decide the governance of the arbitration, that also leaves a leeway room for disputes to arise between the parties. For example, certain parties might not like the location or the venue. Certain parties might not like certain deadlines. There might be disagreements between lawyer parties of both sides, because let's say if one party asks for the statement of claim to be submitted between 1 month, the other party might absolutely go contrary to that, saying that we need 2 months time to submit the statement of claim. There is no time, hard and fast set bound rules to discuss what can be the parameters of ascertaining what is right and what is wrong. Therefore, a lot of disputes may arise out of this. The selection of arbitration panel might be another disadvantage in this regard, because in an institutional setup, what we see is that there's a panel who selects the arbitration, the arbitrators, depending on the expertise of the dispute, depending on the expertise or the subject matter of the dispute. But in the situation where we are dealing with where the parties have to choose the arbitration panel, there might be bias, there might be national bias, there might be insufficient expertise, less knowledge of renowned foreign arbitrators, which may affect the choice of arbitrators and in turn affect the outcome of the decision that might arise out of the arbitration. And lastly, we come to the point of, like as we discussed, the failure to cooperation, which brings us to uh, ex parte proceedings. Now, in an ad hoc arbitration, going forward with an ex parte proceeding is extremely difficult. An ex parte proceeding can be challenged at any point in time, saying that there was impartiality on how the award was passed, and the party present often has to bear all the costs in an ex parte proceeding. So, from a procedural point of view, there is a lot of misunderstanding between what is to be done and what can be done in terms of an ad hoc arbitration, which gives to a lot of confusion and a lot of disputes. And we've often seen that these disputes getting bitter through time. So that is one of the problems. These are a few of the problems that we often face while dealing with ad hoc arbitration. However, in institutional arbitration, there are a few advantages. They are: the reputation of institutional arbitration centers are foremost. For example, if you're giving your submitting your arbitration to an ICC or an LCI, it's that they have a proven track record of giving you proper justifiable awards within a proper frame of time, and it's well managed. It's equitable in terms of timelines, and whatever the management costs are, you have to give it to the arbitration institution. But everything else is not your concern. It goes smoothly as it is managed by the institution. So the reputation of the institution is foremost. The supervision. Now, every stage of the arbitration is supervised by that of the panel of arbitrators in the institute. Okay, so every step, the timelines, the review committee, everything is set. So the quality control is world class in terms of in arbitral institutes. So that's an extremely positive point to go forward with an arbitral institute and not with an ad hoc. Now, in an institution, they have a set of panelists. Now, these panelists are market leaders in different fields of arbitration, some in oil and gas, some in construction, some in other fields. So when you submit your dispute to an arbitral institution, depending on your subject matter, your quantum, and the gravity of the dispute, the institution chooses the arbitrators, and the whole array of choices that are in front of you to choose your arbitrators from are wide in nature, and which gives you an ambit to come up with, to be more sure about the award that is going to arise out of this arbitration proceedings. Moving on, we'll just sector upon a few disadvantages of institution processes. Now, of course, it's way more expensive than an ad hoc process. Now, an ad hoc process, you don't have in management fees, whereas the administration fees can be humongous in terms of institutional processes. The rules of an institution can be bureaucratic, and which certain parties might consider to be impartial at times. And other than the fact that there might lie a lot of sovereignty issues, that if a state is involved in an arbitration, more often than not, a state often tries to question the authority of the administrating institution, that is the arbitration institution, for purely political reasons. So, which often hinders the process and progress of arbitration. So these are the few advantages and disadvantages that we face normally while dealing with ad hoc and vis-a-vis institutional arbitration.